Hi, and welcome to Currently Speaking, the podcast of the Current Consulting Group. I'm Bill Current, president and founder of the Current Consulting Group, and I'm joined today by Yvette Farnsworth Baker, who is our attorney who works here at the Current Consulting Group. Welcome, Yvette.
Thanks, Bill. It's always great to be on these with you.
Thank you. Great to have you. One of the things we do at the Current Consulting Group is we track state laws that affect drug testing. So it could be a drug testing law, it could be a marijuana law, it could be a workers' compensation regulation, et cetera. But if it affects drug testing in the workplace, we track it. And if you're one of the subscribers to our state law database service, Current Compliance, then you know that there's just tons and tons of information in there because there are literally hundreds of laws, regulations, case law developments, et cetera, including all the marijuana laws that can have a direct impact on workplace drug testing. And one of the things we want to talk about today is the difference between mandatory drug testing laws and voluntary drug testing laws. And I know voluntary law sounds like an oxymoron, right? But there is such a thing as a voluntary drug testing law. Yvette's going to walk us through that. So Yvette, what's the difference between those two types of laws when it comes to drug testing?
Sure. I'm sure there are so many laws we wish were voluntary, right? No, when we talk about voluntary drug testing laws, what it is it's a series of laws that regulate how an employer drug tests. And if an employer chooses to comply with that program, then they receive certain benefits. And the most common benefit that employers receive from complying with this voluntary drug testing program is that they can receive a discount on their workers' compensation insurance premiums. Usually it's like a 5% discount. So if an employer wants to drug test and wants to receive this 5% discount on their workers' compensation insurance premiums, they're required to test in a certain manner. And all these different states have different requirements. Some are very specific in how an employer has to drug test in order to get that discount, and others are just have a few requirements. Say you have to have a written policy and you have to do confirmation testing, but they're not so rigid in the way that an employer can test. But because these are just voluntary programs, an employer in that state who doesn't want to test specific to that testing program, say they want to do on-site testing, or they want to do like a new kind of testing. They want to do breath drug testing that's new, or maybe they want to do oral fluid testing and that particular voluntary law doesn't allow oral fluid testing. They don't have to comply with that program. That's why it's voluntary. If they choose to drug test in a different way, they're not in any legal hot water. They're not risking any lawsuits. It's perfectly legal. They're just not going to receive the benefit of that voluntary law. They're not going to say get the insurance premium discount for following that voluntary law. So those laws really truly are voluntary. Employers who look at those laws and don't want to test in that manner, they don't have to. They're just not going to receive the benefit attached.
So outside of the voluntary law, in most states, they would be governed by what? They're just free to do whatever they want?
Well, they're governed by state law still. We don't have any states that specifically have a voluntary law and a mandatory law when it comes to workplace drug testing. So say in Florida, the voluntary law says this. There's not, in addition, a mandatory law that says that an employer would have to comply with. The one caveat to that would be state marijuana laws. They're not always categorized like a state drug testing law, but those are always going to be mandatory laws. So if an employer doesn't want to comply with the state's voluntary law, they do need to double check with the state's marijuana laws to make sure they're in compliance there, because that is still going to be mandatory.
Okay, and you mentioned Florida, so can you give us some examples of states with voluntary laws?
Sure, Florida, Ohio. Let's see, Bill, you can probably name as many as I can. Let's see if I can think of some more.
Well,
What do
one of
you
them
have
that
on
comes
your
to mind
mind?
is, one that comes to mind is Georgia. If I'm remembering my state drug testing law history correctly, Georgia was the first state to pass a voluntary drug testing law, followed by Florida, but there's many others. You mentioned Ohio, Tennessee, Arkansas. And some of them offer different benefits than workers' comp premium discounts, right? I mean, we have some states that
That's true.
offer different types of incentives. And I'd like to ask you what other incentives there are, but also the fact that these programs seem to be sort of inviting or encouraging companies to conduct drug testing, but they're giving them guidance to help them do it the right way.
Absolutely. Absolutely. So, some other benefits that are offered oftentimes by these voluntary laws are protection from lawsuits. The law might say an employee can't sue for wrongful termination or violation of some human right based on your drug testing program. If you're testing in compliance with this voluntary program, then you're immune from employee lawsuits related to your drug testing. Or sometimes they offer the ability to deny unemployment compensation or workers' compensation. If you fire an employee or if a worker has an accident and then tests positive and you've tested in compliance with the program, you can automatically deny unemployment compensation or workers' compensation based on that positive test result. That doesn't mean that you can never deny unemployment compensation or workers' compensation based on a positive result if you're not following the voluntary law, but they make it very easy if you're in compliance with the voluntary program to do that.
So a state might have a workers' comp regulation that provides guidance on how to do drug testing or which specimens to use or under what circumstances, et cetera. And a company who's interested in possibly having the ability to move to deny a workers' comp claim could follow those guidelines and possibly qualify for that benefit. That would be another form of voluntary testing where it's not mandatory that you test this way, but maybe if you're in a safety sensitive industry and you're possibly going to find yourself in a situation where somebody tested positive following an accident, and now they're filing a workers' comp claim, you might want to be in a position where you can move to deny that claim based on the fact that they tested positive, and therefore, according to that law, we're not saying a drug test proves impairment, but according to that law, the drug use was perhaps one of or the reason why the person was impaired on the job and was involved in this accident. But that would be another form of voluntary laws. Would there be times where it wouldn't make sense for a company to want to comply with the voluntary law, the financial benefits, et cetera? Is it something where it's really sort of depending on the company itself and what their objectives are?
Yeah, absolutely. So a lot of companies are doing this for the financial benefit, say the insurance premium discount. I'm going to take an example of Florida because I know of a specific example of a big employer in the state of Florida who chose to test outside of the voluntary program, and this is the reason. They were utilizing the voluntary program in the state of Florida to receive the insurance premium discount. In the state of Florida, the voluntary drug testing law doesn't allow testing using oral fluid. It's specific to urine for drug testing. This employer looked at the numbers and decided that they could save a lot of money by doing oral fluid testing. And to them, the savings that they foresaw in doing oral fluid testing was greater than the savings in complying with the voluntary law. They were still making sure that they were on, good footing using, you know, good good providers and a good testing method, and they felt confident that their program was legally defensible. But they got more savings by using oral fluid testing than they were going to get by complying with the voluntary program. So that's definitely something for employers to think about if they're operating in states with very restrictive voluntary laws. If there are a lot of requirements in complying with the voluntary law that are expensive, an employer might look at alternatives and decide if they might have more cost savings utilizing a different testing method that's not approved in the voluntary program.
So a state like Minnesota has a mandatory law, meaning every employer in that state that wishes to do drug testing must comply with that law. Whereas in Florida, it's a voluntary program. And outside of that voluntary program, there may not be restrictions on how a company conducts drug testing.
Exactly. And in the voluntary states, I think almost all of them have very few, if any, restrictions outside of the voluntary program. So if an employer in a state with a voluntary law wants to test completely differently, they're almost, you know, unrestricted in doing so.
So we've talked about mandatory laws like in Minnesota. Any employer in that state that wants to do drug testing has to comply with the Minnesota drug testing law. And then, of course, the voluntary laws that you just talked about, like in Florida, where outside of the voluntary law, employers may not be restricted by any kind of law. But what about states that don't have a mandatory law or a voluntary law? What governs how they do drug testing in those states?
Sure. Well, like we talked about, marijuana laws, those are going to impact almost every state in this day and age, and those are mandatory. So, marijuana law is going to impact drug testing. Oftentimes, a laboratory licensing law affects the way an employer can do drug testing when it comes to rapid on-site testing. If an employer wants to do rapid on-site testing in the workplace, rather than going through a laboratory. The laboratory licensing laws might affect their ability to do that. Additionally, in a few states, there are things like the state constitution that can affect the way an employer does drug testing. For example, the state of California, their state constitution protects the right of privacy of all residents of California, and the courts have interpreted that to mean that an employee's right to privacy affects the ability of employers to drug test them in the workplace. And courts give examples for, that doesn't mean no drug testing at all, but it affects the way that employers can do drug testing. So sometimes, laws as diverse as the state constitution to a laboratory licensing law can affect employers' drug testing. So that's why it's really important for employers to have good sources that they use, and if possible, professionals that they consult when coming up with their workplace drug testing policies, because they can be impacted by a lot of different laws in that state.
Thank you, Yvette. That was great. Thank you, everyone, for joining us for this edition of Currently Speaking. If you have questions about state drug testing laws, policy issues, or just drug testing in general, contact us here at the Current Consulting Group. You can email Yvette directly. Her information's on the screen. And if there's anything about what we said today that you want to specifically talk about, we're happy to double back and talk about any of those things with you as well. Just visit our website at currentconsultinggroup.com. You'll find a wealth of information there, as well as the various podcasts that we've done over time. So again, thank you, Yvette, and thank you, everyone, for joining us. And this concludes another episode of Currently Speaking, the podcast of the Current Consulting Group.